preamble before the content, I am wondering if there are a lot of people who watch me who have trouble from a time management standpoint reading all the stuff that they want to read, because you cannot transform the sort of stuff you want to get your hands on into audio form that can be read and listened to on the go. Right? So I'm not talking about books. Most books today exist in audible form. I'm not talking about many articles. Many articles exist in audio form. I'm talking about the specific pieces of text, dense text, that you really want to get your hands on and find the time to explore, but it just keeps slipping away from you. The answer will dictate how useful a video like this might be. The answers, assuming I get multiple answers. Alright, that's it. On with the show. I don't know if this is going to be at the start of the next video or after I talk about some other stuff in the next video. Not sure if this is the sort of thing to start a video with, but I need to talk in depth about IP law, specifically copyright and patent law, over the last 4 decades, because that's when it's been made longer and stronger. I've been reading the work of Dean Baker, who is one of these few economists that I have so few bones to pick with that I actually want their work to go viral. But unfortunately, all likelihood, it's not going to go viral, ever. He is going to be one of the economists relegated to the sort of tumbleweed status of economics, where comparatively very few people are ever going to know his name, even though I think his work has been some of the best when it comes to nailing the problem with this IP thing that I briefly mentioned in the video from late December last year, which I don't know if that's going to be the last video or the second to last video, or what I'm going to do in terms of these other things I've uploaded in the meantime. The point is, I want to introduce the YouTube crowd to some of Dean Baker's work. He's got papers on, he's got every single paper, knocks it out of the ballpark. But I'm going to focus on one that is his shortest. It's just 23 pages. And he's actually gotten me to think about, because I've had this IP thing on my radar for quite a long time, but as bad as I thought it was, even I underestimated how bad the IP thing is in the States. And this particular paper goes over it from A to Z. So I'm going to read from some of that. It's been made. IP laws, copyright, patents, and other forms of IP protection, they're not natural phenomena. They redistribute income upward, and it's often portrayed as if it's just organic. It just goes along with economic reality or the increased sophistication of technology. That's not the case. We've made decisions. We've written laws and rewritten laws in specific ways to make the benefits of that, to make it a sort of upward income redistribution. Now, I've known it's bad for a number of years, but I didn't know how bad it was, and I'm gonna read this paper, at least parts of it, 23 pages. I don't know if I'm gonna read the whole thing, but the best thing to do probably is to stop yammering and get on with it, because there's a lot of interesting tidbits, fact-wise. It's all sourced, and again, this is for the purposes of people who maybe need audio as opposed to reading. So you can download the video if you're on the go, but this is one of those few things that I highly advise people to either read the paper or listen to me read out the audio version of it. And yeah, try to spread Dean Baker's work, because every paper knocks it out of the ballpark. I'd love to read some of the other ones, but they go into hundreds upon hundreds of pages. And again, apologies for the construction or the construction noise. I may have mentioned that I hate recording videos during construction time. I may have mentioned that once or twice, and I had a chance to do a recording the other day when it was peaceful and quiet, but it was just one of those days when I was deflated, so I'm stuck with this now. Now I'm wired, and unfortunately, so is the construction crew next door. But I shouldn't bitch about the construction thing, because I've done it way too many times in previous videos, and you all know. And you all seem to live with it. I think it bothers me more than it bothers anyone else. So, all those stylistic qualifications out of the way, on with the substance. So the The title of the paper is sort of tongue-in-cheek. Is intellectual property the root of all evil? Hyperbolic, ha ha ha. He tends to be that way, but it's a wink and nudge at the audience. Of course, it's not the root of all evil, but it's a sort of eye-grabbing title to the paper. So, introduction. This paper raises 3 issues on the relationship between intellectual property and inequality. The first is a simple, logical point. Patents, copyrights, and other forms of intellectual property are public policy. They are not facts given to us by the world or the structure of technology somehow. While this point should be self-evident, it is rarely noted in discussions of inequality or ways to address it. The second issue is that there is an enormous amount of money at stake with intellectual property rules. Many items that sell at high prices as a result of patent or copyright protection would be free or nearly free in the absence of these government-granted monopolies. Perhaps the most notable example is prescription drugs, where we spend over $420 billion in 2018 in the United States for drugs that would almost certainly cost less than $105 billion in a free market. Free market for him is, again, we get into these ambiguities about what exactly is meant by a free market. A lot of people hear free market and they mean unregulated or self-regulated, self-correcting market. Other people hear free market and they still understand that you can have it within the context of state-regulated market. So in the context of Dean, he means free market. Every time he writes it, he means within the context of state regulation. Whether that's a soft regulatory role or something more, that can be debated, but he doesn't believe in this self-correction idea. Self-regulation. He means state regulation, and free market atop that. So just to clarify that. It would almost certainly cost less than $105 billion in a free market. The difference is $315 billion annually, or 1.6% of GDP. If we add in software, medical equipment, pesticides, fertilizer, and other areas where these protections account for a large percentage of the cost, the gap between protected prices and free market prices likely approaches $1 trillion annually, a sum that is more than 60% of after-tax corporate profits. The third issue is that the effect of these protections is to redistribute income upward. This can be seen most easily in looking at the origins of the fortunes of some of the country's richest people, starting with Bill Gates. It is also apparent from looking at the leading companies in terms of market capitalization and profits, starting with Apple. In addition, the demand for people with advanced skills in computer science, biotechnology, and other technical areas is highly dependent on the patent and copyright monopolies, which ultimately pay for their work. With a different set of rules for promoting innovation and creative work, there could be far less demand for their work. While it can be debated whether or not that situation is desirable, the point is that this is a policy decision, not something that is determined by technology or the natural development of the economy. Instead of being a sidebar pursued by a small clique of economists and people concerned about access to medicines, rules on intellectual property should play a central role in debates on inequality. There is a huge amount at stake in setting these rules, and those concerned about inequality should be paying attention. Section 1. The logic of creating intellectual property. Grants of intellectual property are explicitly designed as a mechanism by which the government provides incentives for certain types of activity. The wording in the Constitution could not be clearer on this point. In listing the powers of Congress in Section 8, the 8th item is listed as, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors, the exclusive right to their respective writings and discoveries. This is very clearly describing the monopolies granted by patents and copyrights as policy tools to promote innovation and creative work. Somehow this basic fact that patent and copyright monopolies are tools of public policy seems to have largely disappeared in public discourse. The point matters because everything about these monopolies is determined by government policy, not facts of nature or the course of technology. At the most basic level, the duration of the monopoly is the pursuit of an explicit decision as to how much incentive to provide. The duration of both patents and copyrights have been lengthened in the last 4 decades. In the case of patents, the duration had varied by type but ranged from 14 to 17 years from the date of issuance. It is now 20 years from the date of application. There have been efforts to make it even longer. Copyright duration had been 55 years until the mid-1970s. Since then, it has been raised 3 times and now stands at 105 years. It had been just 28 years from 1790 until 1831. In addition to setting the length of patent and copyright protection, the government also decides what items are subject to these protections. In the last 4 decades, the realm of items potentially subject to patent protection has been expanded to include biological organisms, software, and business methods. This has vastly expanded the range of potential patents. Beyond the question of whether an item should be subject to patent protection, there is also a question of how broadly a patent should be applied. Apple famously claimed that a patent on its mouse/menu system of computer operation. It tried to block the introduction of Microsoft's Windows system, claiming it had the same, quote, touch and feel as Apple's system. Although Apple ultimately lost the case, Amazon attempted to patent one-click shopping in the early days of commercial internet. It also lost its case. While most people would probably agree that honoring these incredibly broad claims is unreasonable, both companies presumably thought they had a serious legal argument, or they would not have bothered with the expense of pursuing their cases. This means it's possible that courts would have decided that any company using menu-based computing or one-click shopping had to pay royalties to Apple or Amazon for the privilege. There's also a question of what inventions meet the novelty requirement for a patent. Under India's patent system, this requirement imposes a high standard, especially in the case of prescription drugs. Typically, to get a patent, India requires that a drug involve a new molecule. This has prevented many drugs that are patented elsewhere from getting the patent protection in India. For example, the cancer drug Glivec, I'm probably mispronouncing that, the cancer drug Glivec, which sells for tens of thousands of dollars for a year's treatment, was denied a patent in India because its courts ruled that it did not involve a novel innovation. I'll link to the specific citation. He does citations at the bottom of the paper. I'll link to those in my low bar in case you want to iron these details out yourself. The U.S. Patent Office is notoriously lax in the standards it applies to patents. It famously issued a patent on the peanut butter and jelly sandwich in 1997. Many companies, especially in the pharmaceutical industry, have taken advantage of this laxness to get frivolous patents. Even a patent of dubious validity may allow a company to extend the duration of its monopoly for several years. This brings up another important aspect of policy, the rules on enforcement. In the United States, rules are very friendly to those claiming patent or copyright protection. Infringers can be assessed punitive damages if they lose a case. This acts as a powerful deterrence for competitors from entering a market where they are potentially infringing until a case has been decided. This again is especially important in the case of pharmaceuticals. If a pharmaceutical company claims a dubious patent on some aspect of a drug that is about to lose protection from its main patent, a generic competitor would take a considerable risk in entering the market. It is also important to recognize the fundamental asymmetry in this sort of contest. The brand producer is fighting to be able to continue to sell the drug at monopoly price. The generic competitor is trying to get the right to sell it at the free market price. Bunch of citations there. The situation in the case of copyrights is even more friendly to the copyright holder. In many cases, the actual losses from even large-scale infringement would be trivial. For example, Spotify pays between 0.006 and 0.0084 cents per play to the holders of the copyright on a song. This means that someone who had circulated 10,000 unauthorized copies of a song would have cost the copyright holder between 60 cents and 84 cents in lost royalty payments. It is unlikely anyone would pursue this sort of case in courts. However, the law provides for punitive damages, which could mean that this sort of violation could lead to thousands or even tens of thousands of dollars in damages. The government has also taken upon itself to prosecute these cases criminally, making an otherwise trivial economic loss into a major criminal offense. The Digital Millennial Copyright Act of 1998 also makes third parties potentially liable for infringement. In order to protect themselves from liability, a web intermediary has the responsibility for promptly taking down allegedly infringing material after being notified. This effectively requires an intermediary to take the side of the person alleging infringement against their customer or friend. By contrast, the law in Canada simply requires that the intermediary notify the person posting the alleged infringing material, after which point they have ended their potential liability. The point is that the value of patents and copyrights, even if they exist at all, is directly determined by public policy. We can write laws in ways that make these property claims quite valuable, as we have done in the United States, or we can structure patents and copyrights so that they provide little return to their owner. If we think that the technology is somehow redistributing income upward, then the problem is that patent and copyright protection have been made too long and strong, not that technology somehow has a bias toward a particular type of worker. The often expressed concern that robots will replace workers and lead to a redistribution from people who work for a living to people who own robots is not actually a concern about the outcome of technology, but rather a possible result of our intellectual property rights. Quote, owning robots is not a technical relationship, it is a legal one. And in order for there to be any plausibility to this redistributional concern, there must be an issue of patent and or copyright monopolies. Robots will almost entirely be relatively cheap to manufacture in terms of the physical materials, capital requirements, and labor needed. If they are sold in a free market with no patent or copyright protections, people with even a middle-class living standard will likely be able to buy robots that would cook their food, clean their house, wash their dishes, and mow their lawn. This could mean a large improvement in living standards, and while the robot manufacturers would make a normal profit, no one would stand to get especially rich from robots any more than people get especially rich manufacturing washing machines or paper clips. The story of robots and inequality is one in which robots are expensive, and this is really a story whereby patent and or copyright monopolies make them expensive. In that case, it is possible that the people who own these claims to intellectual property may become very rich, and most workers are not in a position to benefit from the gains from productivity growth. But it is important that we clearly identify the problem in this case. Inequality is not coming from technology. It is coming from our laws on the ownership of technology. And, as noted earlier, these laws have become considerably stronger in the last 4 decades. So, ties back to one of the points I made in that video late last year about how it's just the happenstance of certain pieces of legislation, nothing that had to be woven into the system itself, as if it was some destiny. There were specific political battles that were fought and lost, fought by those representing members of the working class and hell, even people in the upper middle class. Those political actors lost to the people representing the plutocrats and the oligarchs, and so forth. Specific pieces of legislation. It was not written in stone that these outcomes had to end up the way they ended up, simply because the overarching system is a capitalistic one. Not any more than it was written into some sort of natural law that if you move away from from an economic system that tolerates the use of private property in employer-employee relations, tolerating private property or not tolerating private property does not lead to any sort of ecological friendliness versus ecological degradation. There is no relationship. The Eastern Bloc proves that. And if private property per se is the ultimate source of the problems when it comes to environmental degradation and so on, then I'll just point out over and over again, every time they make that point, and I've seen the point made since the last video, I've seen the point made at least a dozen times by different channels, linking it to capitalism, aka people having a certain perception of what you can and cannot do with private property, right? The moment you point to all that, I'll point to the Eastern Bloc every single time to point out that they were even more industrially ambitious. They were even more extractivistic than, at a certain point in their heyday, right? The Eastern Bloc was extractivist and industrial. So ultimately it ties to fossil fuels. Are these eco-friendly people talking about how if they had just full control of the legislature, we would go off fossil fuels overnight? I don't think they're saying that. I think they're talking about scaling down. You can scale down within the context of an economy that tolerates private property, and you can scale down within the context of an economy that tolerates private property not at all. So, bit of a tangent. I had to, because it ties into this as well. Got too loud, the construction did. And here I am, 4 days later, which tells you all you need to know about my motivation and how much it varies day to day. But to hell with it. Better late than never. I think I'm kicking off at the part I left off, and there's no construction now, but it's raining a bit, so you can hear that on the window panes, which I think is a lot better than what I recorded through after I stopped recording, because it was just insanely loud. So on with the show I go again. The impact of changes in laws on ownership can perhaps be seen most clearly with the Bayh-Dole Act that was signed into law in December of 1980. The main thrust of the law was to allow researchers on government contracts to gain ownership rights to their research. This meant they could get patents or other types of protection on work for which the government incurred much or all of the cost. While Bayh-Dole applied to all types of research supported by the government, it had the largest impact on market for prescription drugs. The government had been funding biomedical research through the National Institutes of Health since the 19th century. The 28 budget is $37 billion. While much of this research did result in important medical breakthroughs, the pharmaceutical industry was not allowed to get patents on the direct products of the research. Bayh-Dole changed this, effectively giving the industry the opportunity to get patent monopolies or other types of exclusivity on research that was highly funded by the government. While this undoubtedly did lead to more industry funding for research, it also led to an enormous increase in the amount the country spends on prescription drugs, as shown in Figure 1. Prior to the Bayh-Dole Act, there was no clear trend in spending on prescription drugs relative to GDP. It had been just under 0.4% of GDP in the 1960s, rising to slightly over 0.4% in the early 1970s, before falling back to under 0.4% of GDP by the late 1970s. After Bayh-Dole, spending began to rise sharply, doubling to 0.8% of GDP by 1993, and then doubling again to 1.6% of GDP by 2002. It currently stands at 2.1% of GDP. Undoubtedly, the incentives created by Bayh-Dole increased private research spending on developing prescription drugs. It presumably also led to better health outcomes, as some drugs would not have otherwise been developed had large health benefits. But there can be little doubt that this change in law governing control of government research increased hugely our spending on prescription drugs. The rationale for the Bayh-Dole Act and other measures strengthening intellectual property claims is that the dynamic gains from more innovation outweigh the deadweight losses associated with these government-granted monopolies. In fact, the evidence on this is far from clear. Cross-country analysis assessing the impact of stronger protections on productivity growth found no evidence of a positive relationship. Citation 8. In fact, most of the regressions found a negative relationship between patent strength and productivity growth. Similarly, an analysis that looked at multi-factor productivity growth across industries found no relationship between the number of patents issued and the rate of productivity growth. But even if there were solid evidence that the dynamic gains associated with stronger patent and copyright protection outweighed the deadweight losses, it's still important to recognize that this policy is increasing inequality. The question is not just whether the dynamic gains exceed the static losses, but whether this difference is large enough to offset whether, he meant to write whatever, but he wrote whether, to offset whatever undesirable impact the policy has on inequality. This last point has been completely invisible in policy discussions on patent and copyright policy. Citation 10. It is also important to note that there are alternative mechanisms for supporting innovation and creative work. For example, as noted earlier, the US government is currently spending more than $37 billion a year on biomedical research through the National Institutes of Health. There is additional public funding through the Centers for Disease Control and other agencies. The government could, in principle, increase this funding by enough to partially or fully replace the patent-funded research undertaken by the industry. The National Science Foundation puts the U.S. industry's worldwide research spending at $62.3 billion in 2013, the last year for which data are available. Not all of this spending is dependent on patents. For example, the industry has to spend money researching manufacturing techniques which would be necessary even if the drugs it was producing were not patent produced. If the government directly funded research, then all the new drugs developed could be sold at their free market price from the day they were approved by the Food and Drug Administration, eliminating the patent rents in the sector. The same would be true for medical equipment and supplies, which also have hugely inflated prices as a result of patent monopolies. If all prescription drugs were sold at a free market price, it would not only reduce the income for the owners of the patents, but it would also eliminate a massive industry that has grown up as a result of the high price of patented drugs. This includes the pharmacy benefit managers, advertisers and marketeers, and the intellectual property lawyers who contest patents in court. The same set of issues arise in other areas as well, even if the immediate consequences may not be as dire as in the case of unaffordable medicines. The government decides not only the strength and length of intellectual property protections, but also the availability of public financing that can either support or compete with patent/copyright financed research. As a matter of policy, in recent decades, government-supported research through various agencies has generally been done with the explicit intent of supporting rather than competing with patent-financed research. This is also explicitly the case with tax credit for research and development. This is designed as a supplement for patent support, not a replacement. It is a 15% marginal tax credit based on prior years of research spending. It could instead be designed as a replacement and cover all research spending, since 15% is roughly equal to estimates of research subsidy provided by patent monopolies. It is worth mentioning an area of government support for creative work that is generally overlooked: the tax deduction for charitable contributions. For high-income taxpayers, the government effectively pays 37 cents of every dollar they choose to contribute to a qualified nonprofit organization. For inheritances, the implicit subsidy is 40%, the state tax rate. While these contributions go to a wide variety of organizations, at least some of them go to support art museums, symphonies, operas, playhouses, and other entities that support cultural output of various sorts. This support is not intended to compete with copyright support for cultural work, but it does suggest a possible alternative that does not involve a government agency deciding on the relative merits of different types of work. As it is, the deduction for charitable contributions benefits overwhelmingly higher income individuals, but it is possible to design a comparable mechanism of individual credits and/or subsidies, which would be more egalitarian. Citation 16. The point of describing alternatives to patent and copyright monopolies for supporting innovation and creative work is that we could, in principle, have mechanisms that allow for the same or perhaps even greater progress in developing technology and creative work, without producing the same degree of inequality. The alternatives mentioned here and proposed by others would have to be examined closely, but the point is that this is an important public debate which is not taking place. Digression, intellectual property, and budget deficits. There have been enormous amount of debate in policy circles on reducing the size of the budget deficit over the last 4 decades. The cost associated with intellectual property claims has almost never been raised in this context. This is an inexcusable omission. As noted before, patent and copyright monopolies are government policies designed to achieve public purposes. The government grants their holders monopolies, allowing them to charge prices that vastly exceed the free market price in exchange for carrying through research on creative work. The higher prices from these monopolies can be thought of as equivalent to a privately collected tax, but for some reason they are never included in any measure of the deficit accrued in a given year or the debt accumulated over time. To be more concrete, if patent and related monopolies allow drug companies to charge $315 billion annually in excess of the free market price for drugs, this is equivalent in terms of its impact on living standards and economic distortions to the government imposing an excess tax of $315 billion a year on prescription drugs. In effect, the government is paying for the research undertaken by the drug companies by allowing them to collect this tax. It is completely inconsistent for those concerned about government deficits and debt to be troubled by the idea of the government would finance research by borrowing, which will then be supported by future taxes, but not be at all troubled by the government granting patent and copyright monopolies that will allow private companies to charge prices that vastly exceed free market prices. The cost of the latter is quite large, as shown in the next section. If anyone is actually concerned about the cost imposed by government borrowing on future generations, then they cannot honestly ignore the costs associated with the patent and copyright monopolies granted by the government. Section 2. The cost of patent and copyright monopolies. In addition to the argument that patent and copyright monopolies are both inefficient and increase inequality, it is important to recognize that these monopolies direct a substantial amount of money in the U.S. economy. There's an enormous gap between the monopoly price and the potential free market price for a wide range of items. This is perhaps most clear in the case of prescription drugs, where we have data on the price in the period after patent protection has been removed, and also on the price of generics in countries where patent protection is not available. Recent research puts the price decline for the branded drug at 90% in the years after they have lost inclusivity. Citation 18. Even this drop may understate the impact of patents and related protections, since often there are subsidiary patents that may still apply even after a drug's key patents have expired. In the case of some of the most expensive drugs, generic versions are available for less than 1.0% of the price of the branded drug in the United States, citation 19. In many other areas, patent or copyright monopolies account for a large portion or majority of the price. The case of medical equipment is similar to prescription drugs. In most cases, the cost of manufacturing the equipment itself would not be very high, but equipment like MRIs and dialysis machines are expensive because of the patents held by the manufacturers. The same is true of a wide range of computers and other information processing equipment. The cost of pesticides and fertilizers is to a large extent attributable to patent monopolies. The same is true of the cost of many non-prescription drugs and medical supplies. Copyright monopolies also lead items to cost far more than the free market price. This is most apparent with recorded music and video material, which would be available over the internet at essentially zero cost in the absence of copyright protection. However, this monopoly protection also raises the price of cable and satellite television and radio services, since these would be available at essentially the cost of making home hookups and the electricity needed if it was not necessary to make royalty payments. The cost of all forms of printed material such as newspapers, magazines, books, and textbooks is hugely inflated due to copyright monopolies. It is important to be clear what the meaning of the assumed savings in Table 1 is. Now, I'm going to skip ahead a bit to Section 3 because it is a very long paper. Section 3, Patent and Copyright Monopolies and Upward Redistribution. Patent and copyright protections not only involve large sums of money, they also redistribute income upward. At the most basic level, there are not many low-income households who receive royalties from patents or copyrights. These forms of protection provide the basis for the fortunes of many of the richest people in the country. Table 2 shows the 100 richest people in the United States from Fortune's 400. The table indicates whether a person's fortune comes from an industry where patent or copyright protections are a major factor in their wealth. While in some cases there is ambiguity about the importance of intellectual property to the person's fortune, in many cases the situation is quite clear. Starting at the top, there is little doubt that Bill Gates would not have anywhere near his current fortune if Microsoft did not have copyright and or patent protection on its software and other products. While Microsoft has also benefited from near monopoly status in the operating system market, this would not be worth very much if everyone could copy the system and manufacture millions of Windows-based computers without paying a licensing fee. There is a similar story with other software billions like Larry Ellison or Steve Ballmer. I have also included the media-based billionaires as owing their fortunes to intellectual property rules. It would be difficult to envision a television network or movie production company being hugely profitable if it was entirely legal for anyone to immediately duplicate a broadcast or distribute copies of a movie without paying any royalties to the copyright holder. These businesses exist in their current form because of our rules on intellectual property. I have put wealth from Amazon, Facebook, and Google in the ambiguous category. These companies, especially the latter two, depend to a large extent on near monopolies in their market segments. On the other hand, they all have made a point of developing cutting-edge technologies on which they enjoy patent and/or copyright protection. It would require a much closer examination of the development of these businesses to assess the centrality of the role these intellectual property claims. There are other people in this top 100 whose fortunes may depend to a substantial extent on intellectual property. There are 15 people among this top 100 who are listed as getting their fortune from some type of finance. It is possible that much of their wealth stemmed from making a good bet on Apple or Microsoft or some other high-flying tech company whose profits depend on intellectual property. There are also 3 owners of sports teams on the list. Would Robert Kraft's stake in the New England Patriots be worth as much if anyone could freely and instantaneously rebroadcast Patriots games without paying him a penny for the rights? Table 3 shows the total wealth attributed to IP and the share of all Forbes 100 wealth. The cumulative wealth of the people placed into the IP category is $490.6 billion, or 27% of the total for this group. The people in the mixed category summed to 298.9, or 16.5% of the total. If these two are summed, it comes to $789.5 billion, or 43.5% of the total wealth of the Forbes 500. This figure would certainly suggest a much lower concentration of wealth without the intellectual property rules now in place. While it is possible that a broader look at very high wealth individuals would change the picture somewhat, there are clearly many people in the Silicon Valley, Seattle, and other tech centers who have accumulated tens or hundreds of millions from software, pharmaceuticals, and other industries heavily dependent on intellectual property. Table 3. The fact that we can, as a matter of policy, decide to weaken IP protections or alter the form of the incentive that the government provides for innovation and creative work means that the demand for the highly skilled individuals that are disproportionately employed in the industries that are heavily dependent on these protections is very directly a policy choice. The government could, for example, weaken or alter these protections in ways that reduce demand for highly skilled individuals by 10 to 20%. This would lead to radically lower pay for a wide range of highly skilled individuals, from software engineers to PhDs in biotechnology. Such a reduction in demand may not be desirable, but it is important to recognize it as a policy choice. Conclusion: technology does not have to lead to inequality. The main point of this discussion is to point out that the flows of income associated with new technology is very directly a policy choice. We have adopted a set of rules centered on patent and copyright monopolies, which have the effect of significantly increasing inequality. We could weaken these rules or alternatively make use of different mechanisms to provide incentives for innovation and creative work. In deciding whether to strengthen or weaken patents, copyright, and related protections, we need to consider whether they are the most efficient mechanisms for supporting innovation and creative work. As the paper notes, there is good reason for believing that this often is not the case, that they are, in fact, the most efficient mechanisms. Furthermore, we should also consider their impact on inequality. Even if weaker protections had some net negative effect on growth, for example, the dynamic losses exceeded the static gains, we may still choose to go this route if there were enough benefits in reducing inequality. And I would disagree with that if we had some sort of a control on the Pareto distribution, or if the inequality at hand were the sort of inequality that touched on or that resulted in extreme poverty or something closely matching extreme poverty. Anything below that threshold or hovering around that threshold. So that's one point where I might disagree with the paper on. Everything else so far is rock solid, but he is a bit ambiguous when he says inequality. Fancy neighborhood inequality? Highly unfancy neighborhood inequality. These sort of things. So, tabling that for now, I'll just resume. Most tax and transfer policies will have some negative effect on growth, so we should also be prepared to tolerate some negative effect from altering IP rules if the distributional benefits are large enough. This paper has just outlined some of the issues to show how much income and wealth is potentially at stake. But the key point is to bring IP policy into the inequality debate. Bill Gates has become incredibly wealthy because we structured our IP rules in ways that allowed him to become incredibly wealthy. This is a policy choice, not an outcome of technology. And so the references which I will flood the low bar section of this video with. So yeah, I mean, he said it all, didn't he? I think for brevity's sake, I should just wrap it up now, because I think all I would be doing at this point is bloviating, and we don't need any more of that, now do we? So, that's a wrap. On second thought, maybe I will add a little bit more, just a minute or so. So I've got a question for those of you who stuck around this long. Good job. Your input is valued, and I'm curious. If you could have a pick of information like this on a specific theme in economics, specifically IP, this paper, let's just say, precisely the information in this paper, you can have your pick to have that go viral, or maybe putting it in viral terms is the wrong way to put it. There's a lot of people interested in economics who don't really go to the internet for their economics, or impacted by economics who don't really occupy the internet. So let's just say if you can have information from this paper occupy the Super Bowl halftime show. And so it'll be widespread, it'll be in the public consciousness as a result of that. And people aren't going to be annoyed that it occupied the Super Bowl halftime show. So it'll be out there in circulation as a result of that. Information from this specific paper. And everyone's going to be talking about IP and how it's bad that it redistributes upward. You can have that, or in place of that, whatever pet issue you have in economics, whether it boils down to the fact that private property is tolerated in employer-employee contracts when you think it shouldn't, either that or you believe there isn't nearly enough tolerance of private property. It's too constrained by state regulation. Like something like that, something more general, or whatever else it might be. I am curious. Because if you ask me, it's pretty damn obvious. The less incendiary, the better. The more closer it gets to something in the way of a purple problem, the better. And this, what I just read out, is the biggest purple problem going today. The less incendiary, the more likely it is that that you're actually going to have enough of a large coalition across party lines, regardless of the country we're talking about, to make a difference. So I'm curious if there's somebody who would pick some bones with that. And if so, I want to know why.